I'm here. I hope you all are able to hear me.
Yes, ma'am. Uh,
Yes, ma'am, you are audible.
Good evening, ma'am. Good evening, everyone. On behalf of Legal Vidya, on
Good
behalf of
evening.
Legal Vidya, I, Rishavraj, member of Legal Vidya, I extended warm welcome to you all to this steamy gathering. Today, we are delighted to host a two-day national workshop on the art of preparing Moot Memorial, a platform that aims to enhance the knowledge and skills of aspiring moot court enthusiasts. This workshop serves as an opportunity to delve deeper into the art of crafting compelling legal arguments and presenting them effectively. Now, Legal Vidya is not just a platform; it is the starting point for the law students embarking on their legal journey. As one-stop destination, we cater to you all the needs of law students, providing a comprehensive range of resources and opportunity, whether it's workshop, webinar, internship, or getting published. We have it all. We offered a platform for law students to publish their articles, research papers, and case commentaries, providing them with a valuable opportunity to contribute them with a valuable opportunity to contribute to the legal discourse and establish their credibility in the field. Now it's a great pleasure and honor that I introduce our distinguished speaker for today's workshop, Ms. Neha Purohit ma'am. She is an accomplished legal professional with an impressive educational background and a strong commitment to academia. She completed her undergraduate study, earning a BLLB honors degree from Gujarat National Law University, Gandhinagar, in the year 2010. Following her passion for human rights, she pursued an NLM in the Human Rights branch from the Government Law College, Bikaner, in 2013. She is a PhD scholar actively engaged in research and since October 2020, further emphasizing her commitment to the expanding the knowledge base in her area of the interest. Presently, ma'am holds the position of assistant professor at the School of Law, Christ Deemed to be University in Delhi NCR. Her academic contribution extend beyond the classroom, as she has approximately 10 research paper published, approximately 10 research paper. Her area of interest include constitutional law, human right, labor law, so encasing her expertise and dedication to these field. So without further ado, let warmly welcome Ms. Neha Purohit ma'am to virtual stage. Now over to you, ma'am.
Thank you so much, Rishabh, and thank you for to the organizers for having me here. And I think am I audible? Are there any?
Yes, ma'am,
Okay,
you're audible.
fine. Yeah. Thank you, Mehak. So I thank the organizers for this workshop. Actually, this will be a learning session for me as well, not just for you guys. And I hope that you get some practical insights from this session, because we will have it today and then we will have it tomorrow also. Maybe possible that I may not be able to complete it in just this session today because of the time constraints, but I'll surely try and take your questions also all together from this session and the second session. So thank you for that introduction, Rishabh. Very, very pleasing and not not that great as a academician, but I would just like to add a little thing about this introduction of mine, that I have had an opportunity of working in different prospects of the legal profession. I've been a researcher, research assistant at the Supreme Court of India with Honorable Justice Gyan Sudha Mishra, which was my placement. I worked at the Finance Ministry as well. I have litigate. Please requesting all of you to please put off your cameras. Just a humble request from my side. Put off your cameras, please. Yes, sir. So then we just started. So I would take your questions definitely. This will get over by 5:50, which I hope to uh, comprehensively deal with it by 5:50. Okay, and around so what I was talking about is that I've had litigation experience also, mainly in criminal matters. And then I am into academics since 5 years now. My area of interest range from a lot of things, but my recent area of interest is genome coding of humans and genome editing of humans and human rights reflection. That's a very very interesting and an emerging area. Do read about it and see if you get an interest into it. For today's session, I would like to tell you before proceeding on to the main subject matter, what is our focus point or to the workshop. I'd just like to take you to these two important things, which is one is the objective, and another is that why are we holding this workshop? Why are you becoming a part of it? When I'm taking up something, no, this is my way of or a pedagogy of teaching and making students learn. What I do is I don't start with the explanation. I just start with questions. Okay. So I hope you all are really interested in the discussion that we are going to take. And I would definitely appreciate if you have an active role in this session. So, what I tend to do is in my classes also, which I've learned from my very, very great and my late professor, which is Professor Malar, who was a professor in NLSIU and then GNLU, is that he always used to come to the class with preparation, very, very thorough, but he always had questions first, and then he used to let us think and ponder over the subject matter, and then only he used to tell us he used to take our opinion, and then he used to tell us what's the answer. So I am very inspired by the pedagogy, which is inquisitive pedagogy of learning. So I'll also copy my professor, which is not copyright infringement at all, because it's a teaching subject. So I'll take you to these slides. You will have to give me answers to what are these, and appreciate your answers. Will not wait for too long for your answers because I need to complete it in time. We have time constraints as well. So first, you tell me, what do you think? Why is it important, and what is the significance? I'll just take you to this very very short PowerPoint presentation. Just let me quickly share my screen. Okay. For this, I'll have to put off my camera for a while. Just let me see if it is possible to put on the camera and then share the slides as well. I hope we have it on our screen. Is it possible?
Yes,
Yes,
ma'am.
ma'am.
Is it there? Is it possible? So can I also be visible and the screen visible together? Is it a possibility? In Google Meet, I don't think this is a limitation for Google Meet. Yes?
Yes, ma'am. You can turn on your camera and your screen at the same time.
I'll just see if it is possible here. Okay. Okay, I think I'm visible as well, and you can see the PPTs. Do concentrate on the PPTs more, not at my uh, screen, not at me on the screen rather. So this is it like, can you view it in the full screen mode or something else? Now I think it's visible. Yes, is it? Can I ask the organizers to reply me? Okay, then I presume that it
Yes,
is visible in full screen for all of you. Okay, so this is, of course, we need to start with some formal title page and cover page. So this is what we are here for. We need to know what is the title and theme of a specific program. So my question one, dedicating this pedagogy again to my late and my great professor, Professor Malar of NLSIU and GNLU. Why are we conducting this workshop, or why are you here at this workshop? I want answers from you guys. Can anybody answer? Put on your mic and then answer because I'm not able to see my entire screen. So why are we conducting this? Why are you here for this workshop? Anyone?
Am I audible, ma'am?
Yes, you are. What's your name?
Ma'am, my name is Mehak Rajpal, and I'm a pre-law phase. I'm yet to enter into a law school.
Okay. So why
So,
are you
ma'am,
here?
yeah, I'm getting that answer. Ma'am, as we know that this workshop is about the drafting of moot court memorial, and as we know that moot court constitute an important part of a law school, which has
Mhm.
many benefits like moot court gives a real court experience. As in 5 years of law school, we are told with the theory of laws and not a practical application. So it gives us real court experience. Also, it helps us to apply law, not just learn and mug up. Also it helps to you know inculcate various skills in ourselves that is required in law, that is research or drafting or speaking. It also helps
Okay.
in cv building
Okay.
and
Okay.
helps in networking opportunities.
No, but my question is, why is moot court important? You have answered the question. Why is moot court important? I am asking you, why is this workshop being conducted, and why are you here? Because these are the same similar questions, synonymous for each other. So, although whatever you said was correct in respect of the relevant subject matter right now, but this is not the answer that I seek for this question.
Good
Anyone else?
evening, ma'am.
Yes. Good evening.
Am I audible, ma'am?
Yes. Yes, you are.
I am Ipsita. I'm a second year student from Gautam Buddha University.
Hmm.
Actually, I am attending this workshop because I have till now participated in three moot court competitions, uh,
Okay.
and I got nothing like I got experience, but failures. So I am here to learn the art of drafting a moot memorial, to
Okay.
learn more and to make my expertise in that, because I do enjoy attending moot courts and drafting memorials, but maybe I'm not correctly learning that art of drafting it. So I'm here.
Yes. Thank you so much, Ipshita. And that's what our answer is probably. See, when we are getting inducted to a law school, we have two kinds of courses these days, which is one is integrated, which I even did for my law school and for my graduation, and there's one 3 years. The problem with a lot of, like Ipshita has exactly pointed out, that a lot of law schools do not give orientation about the clinical education that you are going to take up in the law school itself. What happens is, I'm this is indeed what am I speaking will also be the answer, connected answer to the next question, that how is it different, why is this workshop different. That is one answer that I will take from you. Why I will tell you why is it different, but I will take that answer from you at the end of the workshop. Okay, so let me just address this, why this workshop. See, workshop is always conducted, any kind of workshop, to give you a lot of learning, a lot of insight in a very short span of time, which you do not get in a particular organization. So as I said, that a lot of institutions, like nowadays, I don't know about NLUs. When I was inducted in my law school, which is a topmost premier law school in India nowadays, that time also it was, but I never got orientation about mood. And I always used to ponder about the question that everybody is talking about moods. My seniors are talking about moods, and people who are mooting, they are behaving in a certain attitude that I think I am not able to possess that. So, orientation is very necessary for clinical education. We do not know exactly books, other laws, other statutes we can go and read. Codified and uncodified, everything is taken up. But we do not have an orientation or a specific credit system for clinical education. And mooting is very much an important part of clinical legal education. This prepares you for your industry, this prepares you and helps you in a lot of developments, positive developments in your personality. So we need such kind of orientation out of our education, which is outside class. Pedagogy, again, another pedagogy. Pedagogy is nothing, for those who are very new here. because one learner was saying that she is into the pre-law school stage. So pedagogy is nothing but the way of teaching. Different ways of teaching means pedagogy in academics, in teaching and learning ways. So this is also a legal education subject, and no, most of the law schools will never ever give you an orientation about what is mooting. So what about those organizations that give you an orientation program about exactly what is mooting? There also I find, as even I have been in the same place that you are today, I also find that students are very hesitant to talk to teachers who are the regular teachers. They are very hesitant to approach their seniors, because when you go into a law school, there's a premonition about a fact that you are supposed to know everything, which you do not know, and which helps, these kind of workshops helps in getting you connected to the subject, getting you learn more than what is going to be taken up in your organization. So they basically prepare you, give you a ground, give you a basic footing for trying your hands on this a clinical legal method of learning. Okay, this is the first answer. Why is this workshop being held? Okay, and I would rather tell students, because if you are attending this, you do attend it very seriously. I am telling you, mark my words, very very personal experience to me, that these are going to help you all your life. You only need to concentrate, that's it, nothing else. Second is, how is this workshop different? See, every speaker says this. You know that everybody says that this workshop is different, this course is different, this institute is different. Everybody will say that. Yes, of course, it is different, because as a human, I would say I have a different DNA that nobody has. But that may be a joke. It may not be a joke for you, but yes, it is different, because not because it is being taken up by a person with a very different DNA, not being able to match with anybody in the world. But it is different in the sense that I have been in three stages of this profession. In the stage of a mooter, when I entered my law school, so I have mooted, I have failed in mooting. I would confess that very, very frankly, that I have no hesitation in saying that I have failed quite a number of times in mooting. And thirdly, that I have drafted memorials for my own students in my initial academic experience years, I would say. So, and the fourth point is that I have had an experience of judging national moot court competitions also. So, taking you to this journey in this workshop will definitely help you to understand that what do you require for making a good memorial, and what you don't require for making a good memorial. So you do not make disasters like I did. I completely made a blunder of my first memorial, which was based on Transfer of Property Act. And I was very good with arguing. I would not boast about it, rather, but I was really good with arguing. But the point was, when I entered the courtroom, the teachers who were judging me, they were very impressed by the way I was putting my points. But they when they saw my memorial, it was a complete blunder, it was a disaster. And when I realized it in my second mood, then I thought that yes, that time I was very disappointed when I realized it in my second mood. Then I thought that yes, that was a learning experience indeed for me, like Ikshita pointed out, that yes, you're not able to take this to another level which can help you succeed in making a good memorial. So I would say that my personal experiences from all these four stages will make this workshop different from any other workshop that you have attended. Yes, I know that a lot of recorded videos will be available on YouTube, and a lot of PPTs will be are definitely available on Google and any other sites that you go to, and they will also help you if you're able to catch things from there. That's well and good, but what I believe in is nothing can can be at par with the personal learnings that you take from any person in life, whether be it a teacher or not. So this is my ideology, and my students, all my students for these over almost 5 years now, I've been teaching. All my students know that I believe in one thing, that you learn while you teach, and you teach while you learn. This is my ideology of teaching and making somebody learn. So these are the two questions that I've answered. I would like to take your answers for the second question, which is how is it different from any other workshop, that we will take tomorrow, not in this session, because unless and until you're able to complete this, you will not be able to judge that. And I would definitely welcome any kind of positive and negative feedback, so that even I can know that is there any scope of improvising on to these things. Okay, so I hope this is to some extent convincing you. And in that case, can I go ahead with the next question, like in the same manner of the inquisitive pedagogy that we follow? So can I get this thumbs up from like most of you? If you do that, okay. Yes, yes, Asif, Aisha, they have raised hands. Do you have any questions? I'll take that later. Is it fine? Okay. So then we'll go ahead. Okay. Taking you to this next slide is, sorry, the next one is this is we've done. What is mooting? Why is it important, and who should do it? So you only tell me again that why is what is mooting basically, and why is it important? Thank you so much. Yes, you can relax for some minutes, and then we can go ahead. What is mooting? If somebody would like to answer that, those who have already mooted, they might know it better. So can I get some answers? Okay. Yes, Arif. Arif. Yes, Arif. Please go ahead. Are you there, Arif? Yes,
Ma'am, I
Arif.
don't know anything about it because I am new admission in college.
You are a new admission in college. Okay. Which college
Yeah.
are you from?
Ma'am, Law College MNSU Udaipur.
Udaipur. Okay. Anyone else other than Nipshita? Because taking answers from the same learner, I don't exactly appreciate that. Okay, let's take it from Ipshita only because she is willing. Yes, Ipshita. I cannot see any other hands as well. Yes, Ipshita, please go ahead.
Yes, ma'am. My voting is just like uh, a manifestation or a duplicate setup of official court proceedings. Like we advocate a case in High Court or Supreme Court. Just like
Okay.
that, we have been given a moot problem, a case, and we have to apply our laws and principles and arguments, frame it in a legal document, and then moot, and then argue it before the court, before the
Mhm.
duplicate setup of that court. And it is important because the laws which we are learning, the theory which we are learning, we
Mhm.
we have to learn to apply it on the real life situations, real life cases. So it
Mhm.
is important to, it is like a practical experience of the theory which we are learning in our law school.
Yes, yes. So, in simple terms, what we call mooting is nothing but mocking a trial of a courtroom. You are
Yes,
not exactly mocking the courtroom, but you're just mocking a trial to some extent. It is like preparing ourselves for the procedure that is being followed. So I would say that it helps you in a lot of things, but the maximum to what extent it helps you is helping you maintain the procedure throughout the entire process. And this is exactly making you industry ready for a lot of things. The second thing about it is that why is it important? That I will take a little later. The third question I want to take up first before the second one is who should do it. Now that, sorry, I think yes, I missed one point is for those students who are very new to law school or who are very, who are in their pre-law school stage. Mocking a trial courtroom is also not an understandable or a language in which you can communicate or I can convey my expressions to these students. For them, I would say that you are enacting basically a courtroom trial. So, what are the stages of this trial? Is that you will be given a problem which may be based on a real case or which may be a fictitious case, and there will be facts in it, and you will be given a question as to you have to prepare a memorial or you have to take a defense or you have to prepare pleading for the initiating party or for the defense party. This is exactly what is done in mooting. Now, going on to the third question, that who should be doing it. So, who all should be doing mooting? Of course, only relevant to law students. But what do you think? Who all should do mooting? Anyone? Anyone interested in giving this answer?
I think every law student should participate in moot court competitions.
Siddhant. Okay. Um, why? Why?
Like,
Yes, Surya.
Ma'am, especially the students those who want to make their career in a litigation field, they should do a motive.
Okay. And Vedant Sharma has also raised his hand. Yes, Vedant.
One mode helps you to understand the basic intricacies of the code and the law, and you also think critically from both the sides to
Mhm.
identify the strength and weaknesses of the case.
Yes. So all of your answer is related to the right answer, but Siddhant's answer is the correct answer. That even in my opinion, that's a personal opinion. Even in my opinion, I think everybody who is inducted in the law school should do it once. Why am I telling you? Because see, I'll tell you one thing, that as a law student, I never liked mooting. I was always interested in paralegal activities, that is legal aid. I was a member of the legal aid committee as well in my law school, and I was never ever interested in mooting. I only mooted in my third semester, which is the second year, third or fourth semester probably, and that was a disastrous memorial that I made. That was the time that I made a disastrous memorial on TP law. So till that time nobody told me that mooting is I've always used to hear that mooting is just important for those who take up litigation. In my opinion, it is not so exactly. Why? Because it does not only give benefit or advantages to persons who are going to pursue their career in litigation. We have a lot of different avenues to our personality and a lot of different dimensions to discover when we are learning certain professional or particular technical courses. And law is one. Like humans are social beings, they cannot stay alone. Law cannot also stay alone. It's a dimension of social science. So when you take up activities like this, it develops a certain kind of scientific temper, research temper. It makes you an advanced learner. It gives you self esteem. So for every profession, these qualities are a must. For every profession, not being in profession, also being an individual, for improvising your personality in a day to day life, you need to have these attributes in your personality. So why not test ourselves? So even when till the second semester, third semester, I never felt that I will moot, because whenever I used to look at my seniors, they had this. There's this one very renowned tier one law firm partner now, who was my senior, and I used to look upon that person all the time, and I used to think that what he has, I will never have, because he's done so well in mooting. He's gone to international moots. He's done so well. But when to the point when I realized, when I went for Delhi University moot from my university, which was the second time I made the moot memorial and I got through for the seventh position, then I realized that there was nothing different in that person that I could not have. It is just to test my temper, to test myself on the touchstone of this thing, that to break this hype of mooting, even I can do it. But I never took up litigation as a choice of profession. What I took up was I became a research assistant in Supreme Court from my placement. So I never ever thought that I will litigate ever. Litigation just happened in my career by chance. I was never interested in litigation. So it is not just for your litigation prospects to moot, because moot is exactly as I said, it is not exactly mocking a trial. It may be very, very different from what you see in a courtroom, and it the difference may be extending from like watching a film which is Damini. In my when I was growing up, I saw this film about a rape case which was Damini, and which won a national award and what all. So the difference between mooting and a real courtroom trial will be exactly the same difference between a real documentary series on a particular case and watching a 90s movie, which was Damini. I would idealize that. So these are two different perspective, and you need to have a lot of things other than mooting, other than just academics, to develop your personality. This is why I would say that everybody should try it once. That's your total call. Sometimes you may not be good at mooting, but you may be good at litigation. I've seen people who've never mooted their life, but they are doing very well in litigation. And sometimes you may be very good with mooting, but you may not be able to develop the patience and the temper that litigation requires as a career prospects in legal profession. Okay, so this is our answer of who should do it. Now, and the answer to why is it important? Why is it important? Why is it important? Mooting is important. Why? What do you think it's important for? Yes, Sumit. Yes, Sumit.
Ma'am, because I feel it does not involve any one particular skill in specific, but a myriad of skills. Like you have to do research, you have to prepare your written submissions, you have to do
Mhm.
the advocacy, and then you have to present the case in a persuasive manner. So I think these are the core skills which
Mhm.
the law or the subject of law enables you with. So, like to do it is to get fluency or get better in all these skills.
Okay. So, to some extent, Sumit is right. It's just that I have a little more comprehensive sorry, excuse me. I have a little more comprehensive answer to it. You may add to it. So before we go on to the exact subject matter of how do we draft a moot court memorial, I would like to take you to this answer. Why is it important? If you wish to write down these points, because, or if you wish to ponder over it, you can take a just screenshot and then uh, you can go through it. So why is it important is given in the next slide, which is your taking you to this slide is this one. Does it have any benefits, or is it important? Why is it important? It is important for the sake of these all these points that I've mentioned in these pointers, and I'll just take some of them in detail, and because all of them are connected, so need not to be deliberating upon each and every point of it. First, taking the point of advanced learner and building self-esteem. How do we become an advanced learner by mooting? I will give you an answer to this question by sharing an experience of my own mooting, probably paper writing. Okay, what happened is that now is it coming to the right one? Benefits advanced learner, is it coming to the right one? I hope. Yes.
Yes,
Okay.
ma'am.
Yes, thank you. Then I think it may be a technical glitch at your end. Some students, some learners are saying that it is not visible. It may be a technical glitch at your end. So benefit is advanced learner and becoming an advanced learner and build your self-esteem. How do we become an advanced learner? See, I have written, there's this moot court which I did not, I judged. I did not write the memorial for it. I judged this moot court. And when I was judging it, it was on media law. So I was not teaching media law. It is also a learning process for a judge as well. This is what I'm sharing with you. Why? Because the students who had appeared for this moot in this competition, they were in the fifth semester, and usually fifth semester students do not get to learn media law. It is in the seventh or the eighth semester that you get media law, which is also an elective subject. So you have options to choose this. So what happened is that these three girls, not a very bright one from their class, but then above average, they came to me and they said that, ma'am, would you like to guide us, become a mentor on this moot problem, which is on based on media law? And I said, okay, I'll try my hands on it. I've never taught media law, and I do not have much experience on it as well. But as teachers, we need to take different avenues, and as students also, I would like to tell you one tip, that never hesitate from experiencing a new law, because in this profession you will always and always have laws being built up, laws being repealed, laws being taking place of some other laws. And in this emerging world of technology and biotechnology and your information technology, you will always have new avenues and new problems in the society coming up. So never ever get stuck with this thing that I will not teach, or I will probably not take up this case because I don't know. This is a learning, very, very great learning process for you as well, and self learning that too. So these two, three girls came to me and they said that, ma'am, would you like to become a mentor? I very hesitantly I said that yes, okay, I will try and help you out, but I'm not sure whether I'll be doing justice to it. And you would not believe that these three girls, very average girls, they won this moot court competition and they won all the three prizes, not just the researcher, but the oral rounds also, and they got the highest in every law school. Okay. So and now these students have been writing several articles on topics related to media law which they have not even discovered. So this is a clear cut and a classic case, very practical, very, very personal learning, wherein I have seen that people who are in their initial semesters of the law school, but still they are very keen on learning laws. But initial blockage is your hesitation. You hesitate that, oh God, I do not know procedural law. How am I going to take this up? Sometimes you have procedural glitches in a moot court problem, and you have not learned neither of the criminal nor the civil procedure code, and you're not able to take up that. So do not hesitate in it, because it will give you an upper hand. Even if you do not win the moot court, in that case also you will gain a lot of knowledge about a new subject, and this will indeed help you build your self esteem. Now that I have written papers on data protection, and now India does not have a data protection law, so I wrote this paper in some 3 years back when it was lockdown, and I knew nothing about this conference that I participated in. And even I got the third prize for it, second prize, sorry, not the third one, the third second prize for writing this paper. And there was one external who was invited from University Harvard, and he was judging this moot court, and he really appreciated the efforts that I'd put in. I at one point of time when the conference got over and when I was felicitated, I believe that this happened just by a chance. Then I looked at my paper, I sent it for reviews after the conference got over, and I got a very good review. So it's just not for mooting, but for researching and writing papers also, that you build your self esteem when you are at low at esteem, and you become an advanced learner in case of the subject matters that you've never learned. This is especially I'm pointing out for the students till the fifth semester, because you do not deal with procedural laws till the fifth semester in most of the law schools. I also learned my procedural law in fifth semester. Okay, so do not hesitate and take the lead, and try. You will get solutions for everything. For everything, then it tests your ability and your knowledge also. How much of things do you know, to what extent you are able to discover new things and avenues to a particular solution. That is also done through this clinical legal education exercise. And of course, as Vedant very correctly pointed out, that it makes you a very, very good researcher only in the fact that when you are interested in researching things. So when you are looking for a particular solution to a moot problem, what happens is sometimes you get solution to other problems also. Like this happened in my first disastrous moot court memorial, which was based on transfer property and sale of goods, what I knew that I did not know a concept of sale of goods. And when I was researching of the transfer property act and sale of goods, I found that this was the answer I was looking for that I did not write in my exam. Although that was not my focus point, but you take this as a positive development, even if it is what not asked in an exam. You are clear about the conceptual part of it. Okay, so you build your research temper, you become a great researcher, you build the habit of reading a lot. And this also helps you to do one thing which is a requisite, which is by avoiding which you will not be able to succeed in legal profession, is just reading and understanding precedents. What is precedent? Precedent is nothing but earlier judgments of the Supreme Court. Okay, because Article 141 is the binding jurisdiction of the Supreme Court of the Constitution of India. And when you are reading a particular judgment, you have a way of interpreting and reading a judgment, and this is how courts take out important matters from a particular decision while giving a current solution, while giving solution to a current case law. Okay, so you develop all these tempers. And at the end, I would say there may be a lot of comprehensive points on this, but this is what I have been able to recall and I have been able to experience. Is at the end, I would say that all these benefits of mooting as a paralegal, sorry, as a clerical legal education subject will help you become a smart attorney at the end. Because but it is not that you are only mooting. You have to carry on. You have to continue with these habits, with these demeanors all your life. Okay, so don't just get boasted by just one winning one moot and then sitting for the entire 4 years and then not practicing all these things. This will help you a lot. Only persistence is required. And the last thing for today's session, because I believe we should be winding up by now, is that this will help you become a smart attorney. This will help you become an efficient judge, all these habits, and this might also help you land up becoming an excellent researcher. So why not try on it? And even if you do not become any of them, you still have these personality attributes which will be counting towards your improvisation in any profession. Even if you leave mooting, you need confidence for any kind of work. And this is a simple reason that I posted the picture of the current CGI, because what could be better than idealizing this profession through these clinical legal practices, uh, other than becoming a CGI of the country. And I suppose that most of you appreciate him being a judge, being a lawyer. Yes, you might not agree with me as well, but this is what I feel, that he has everything. Not that mooting has led him to do all this. No, I'm not saying that. Other habits also have led him to become a CGI, but then these things will definitely help you, and they will not give you a disadvantage at all. Even if you fail, they are not going to cause you a disadvantage at all. No learning is a disadvantage at any point of time. Okay, so never think that learning is a wastage. And always if you're spending or you're investing time in something, do learn it with all your heart. So for today, I'll wind up here, and I'll take your leave because of the time constraints that we have. I'll take the subject matter tomorrow. What are the parts of a memorial, and how what all cares should be taken while we are drafting this moot memorial. I hope to see you, and I just need to get connected with one of the organizers. Thank you so much, Paris, for briefing up yesterday's session, and I hope you all do carry uh, that brushing up of yesterday's session. And I know that you are all excited and definitely waiting for the main contents of drafting a memorial. But whatever we discussed yesterday was very, very significant for the point of for the fact that unless and until you know the background and the foundation of any kind of clinical learning process or subjects, you will not be able to master over the thing of drafting a memorial. So I'll take you to this next part of the workshop, which is the main subject matter of drafting a memorial. Now, as we were discussing it through these slides, going through it, that why is this mooting, what is mooting, why is mooting important, what are its benefits, we've all done that. Now I'll just take you quickly to this uh, contents or the composition of how what is a moot, how is a moot memorial comprising of, and what all are important things, and how do you write them, inculcate them in this memo. Before that, I just want to quickly tell you that what is a moot memorial. As I'll share my screen here. Okay, uh, just give me 1 second. So we ended up here. What are the benefits? And now we'll go to what is a moot memorial and what are the contents of this moot memorial. You can quickly have a look at this. What did we do yesterday? And these were the questions that were answered. As I told you that my pedagogy is never to explain things first. My pedagogy to teach and make somebody learn. And even I believe that I can learn faster by putting questions first to myself and then seeking answers for them. Okay, not that explaining one thing and then going back to the question and answer method of learning. So when we talk about a memorial, memorial is nothing but a document. Okay, and this document is about how do you advance your arguments in front of that bench. Okay, I would like to know how many of you can just raise your hand, how many of you have drafted a memorial till now. Whether you succeeded in it or not, that's not the question. Yes. Four. Yes, yes. Okay. So, very less number of people have drafted it. Now it's increasing. So, I believe almost if 20 people have already done it, then maximum number of people have not done it. And what could be the reason for not drafting? I can understand sometimes we are not interested, sometimes we have we feel that we are not competitive enough, and sometimes we feel that why to test our knowledge and ability. Okay, so mm, when you draft a memorial, you have to follow a certain format which is almost similar but to some extent different for every university. So how is it done? First of all, okay, fine, thanks. How is it done? How do you start with drafting a memo? What is the first thing that you take into account when you draft a moot memorial? Anyone? First thing that you take into account while you draft a moot memorial. Yes, Ipshita. Ipshita?
Yes, ma'am. Ma'am, am I audible?
Yes, yes.
Ma'am, as for me, first thing which I have taken into consideration was the issues which are which we have to figure it out while the very first thing is the reading of the mood problem, and after it framing.
Okay. I have another
So
answer.
I
I think.
was
Okay, Ipshita, thanks, thanks. Divya has also raised her hand. Yes, Divya. What is
Hello,
the
ma'am.
first thing that you take into account?
Ma'am, the first thing which I take into account is reading the preposition, what it is about, and focusing on the issues, and
Hmm.
through which I make my memo and work on it.
Okay. Yes. So you are right in it, but I would like to tell you one thing, that the first thing to get started with a moot memorial is first of all go through very in deeply into the parameters given by each and every university. Sometimes what we do as students, we're quite excited to just approach the problem and get a solution. We tend to forget what are the formalities that we need to complete. And in a moot memorial, I'm telling you very frankly, because as I've judged it so many times, in a moot memorial, what happens is we have to take into account all the requisite things, that even if you are exceeding your page limit as well, then also your marks can be deducted. So first thing that I as a student would have got started had I been got an orientation like this that you are getting, I would have started first of all looking into the requirements of each and every moot competition by the university, which also will include that going through the problem, of course it is, and going through the procedural aspects of it. What color do they want for it, because we have different colors for respondent and your petitioner. Which side do they want for it, and how many pages do they want it, what is the line spacing, everything. Why am I telling you is that because if you do not go through it, every step has a certain number of marking. Sometimes your memorials get rejected for the fact on the first place, which is called as dismissal in limine in a court. If you go to a court and the court thinks that the petition is not maintainable, it is just not a matter that the court should take cognizance of your memorial, or I will compare it to a petition in a court only, it gets dismissed. Of course your procedural points may differ, procedural requirements for a moot court competition and procedural requirements may differ for a court. Okay, so your memorial can get rejected on the basis of not following the formats or the requisite things that are required by university. You never just get started with a moot problem. Okay, one thing. Secondly, what you have to do is you read the moot problem very clearly, make notes of it, and then take out what are the laws involved in it, because when you are reading the mood problem, which is the most essential thing that you will get a solution to this problem, is the application of laws. We will come to that, because in our pleadings the most significant things that you do not apply a law correctly, your entire problem is not getting to the right path of seeking a solution, okay, seeking a resolution. So it happens like in a maths numerical, because I have had an opportunity to study science. So what happened in physics, we used to have numericals, and from the beginning, if you are getting that numerical wrong, of the formula wrong, your entire answer will be wrong and you will not get any marks for it. This is the same with this moot memorial. Now after this you have seen, after this you have checked what are the laws applicable. And yes, there's one more thing which is very important: to choose your team very wisely. You have to be, if you are in a team of three, maximum time it's a team of three only, you have to be taking the lead, every one of a moot team. Not just one researcher can do only research, and the speakers can only draft it, and the speakers only have to practice arguments. Everybody has to take a lead. You have to motivate your team members also. After that only I will get, as a student, if I put myself in your place, after that only I will get into this uh, concrete process of drafting a moot memorial. So we are done with these two processes, three processes actually. And I know that team choosing is not in our discretion most of the times. Maximum times we do not have a team, we do not have an option to choose a team. Yes, if you are fortunate enough that you are on the same ranking, that your friends or the people whom you repose confidence on, they are on the same, then you can get the same team. Secondly, never to the second stage of it, that memorial drafting is, first look into, have a look at the contents of a memorial drafting, which is of course starting with the cover page. Then you have table of content. Cover page is very important. Can anybody tell me what is the significance of a cover page in a moot problem? Moot memorial, sorry, not a problem. What is, how is a moot memorial cover page important, or is it just like a formality to be done that everybody puts it, we'll also put it? Yes, yes, I think yes, yes, you can reply.
Good evening, good afternoon, ma'am.
Good afternoon.
Um, the,
Yes.
co- the cover page is very significant. Firstly, it describes the jurisdiction in which court we are applying our pleading.
Hmm.
Secondly, which laws, like SLP, it is there, or it is writ petition. Thirdly, the party's name. specifying
True.
the party's name. If the party's name is wrong, it definitely get rejected from a front page only. Then comes to the last line, like color of the cover page is also very depictive. Sometimes people don't pay so much attention; they just go with black and white. As I have seen in my three moods, people don't choose to have a color copy, so that also get a deduction. So definitely, the cover page holds two most important: the parties and the jurisdiction.
Yes, yes, yes. That's exactly the answer to this. That cover page is giving us the details, the broader details of a moot memorial. First of all, it will contain name of parties. It will have the court to which you are see from which you are going to seek a redressal. It will have the law under which you are approaching the court, and it will also indicate on whose behalf you are making this petition or presenting this memorial. Okay, so there are two parties in every dispute. If it's a uh, criminal matter, which is I will be connecting it to the very practical aspects of going to exactly a case law. And then, so for those who are very new to law schools, and for those who have not learned procedural law, I would like to tell you that there are majorly two kinds of courts that deal with cases in India. And these two kinds of courts are exclusive of the High Court and the Supreme Court, because the High Court and Supreme Court have extraordinary jurisdiction, and they are constitutional courts. So they never deal with exact civil or criminal matters. These are all dealt with by the lower courts, which is till the session if it's a criminal matter, and till the district court if it's a civil matter. So, not going into the details of criminal and civil, I hope you all understand that we have time constraints, and then this is something that's very, very general. You can understand on yourself. Just for a hint for those who do not know at all what is a civil and a criminal matter. Civil matter only deals with private rights, and criminal matters deal with rights which are right in rem, right, not in personam. Okay, so what happens is when you are writing something on your cover page, you have to clearly mention whether it's a criminal case and whether it's a civil case. How do you understand that? If you've been given a moot problem which is based on criminal law, how do you know that we will have to put these parties' name on the cover page? How will you understand that? Is there any particular terminology for parties in a civil law, in a civil case, and is there any particular terminology for parties to a criminal matter? Yes, Pragya, I think. Pragna. Yes, Pragna, you
Ma'am,
raised
for
some.
civil law, yes, ma'am. For civil law, it is a plaintiff and a respondent, and
Mhm.
for the civil law, it would be civil law, ma'am. I have a doubt because I get confused with the terms, but for civil law, this is
Okay,
the
that's
answer.
okay. Okay, I'll. Anyone else who can give us clarity on this? Yes, Arif.
Ma'am, in civil case, there is a defendant and a plaintiff,
Hmm.
or in civil case, in criminal case, there is accused.
Okay. So I think we all need clarity in this respect, because those of you have not answered, I presume that you don't know, or probably you are not willing to answer that, and the presumption is more in on the side that you don't know, and those who have answered, they have not correctly answered it. See, if you wish to note down this, you can note down this, because these are things that you will not learn. Not every law school teacher will tell you that these are the parties that you have. They will just go on with the words, and you will never understand them unless and until you are inquisitive about the fact that why are you taking these names in this place. Okay, for a cover page, it is very important to identify the correct terminology for a civil and a criminal case. For criminal cases, if you wish to write down the name of parties will be prosecution and your accused. Okay, and defense, sorry, prosecution, accused, or prosecution or defense. And for civil, this is for criminal that I pointed out, and for civil cases it will be always and always plaintiff and defendant. So if you miss these names or interchange these names by any chance, your marks are surely to be deducted, and definitely when you enter for your oral rounds, they will definitely point out these mistakes, that even if your marks are not deducted at that stage, but the a judge who is very particular, like I am a judge, I would be a judge who's very specific about the terminology in law. This has been taught by my own professors to me. I would definitely point out that why are you using these names? What is the significance of using a plaintiff term in a civil case? Okay. Yes, Vedant, do you have a question?
Yes, ma'am. I attended one of the moot court competition, and it was like a moot court competition, right, ma'am? And the I and also the other participants addressed the both the parties as plaintiff and respondent, but the judge never pointed out anything like.
Very good. That's a very good thing that you pointed out. You could have not, you definitely did not point out at that competition. I'll tell you why. Because, see, I would not say that every person is that specific, or every person themselves knows that what is the exact terminology. Sometimes people who are judging you may also not be that competent. I'm not pointing out towards anybody, but you are very right in the fact that if you are not questioning it, definitely there's something wrong with your own learning process. Okay, which I think that the term used for such persons, if they've not pointed, is incompetency. So probably it's a institution's choice whom do they appoint for judging someone. That's totally their discretion. But in that case, you, if I have pointed out this, you please, now that you've got a clarity that why are they not pointing it out, you will definitely know that what kind of parameters do they keep for people, for marking people. Okay, so it should have been pointed out, but it has not been, which was not correct. Yes. Moving on to the next thing. Now, cover page party's name should be exactly the same terms that you use for civil, criminal, and if it's an appeal, if whether it's a criminal appeal, whether it's a civil appeal, you will only use terms, because appeal is going to be made to a higher court, and there the differentiation of terms using courts is not used. Maximum times appeals are going to high court and supreme court. So for appeal, if you're going, whether it's a criminal appeal, whether it's a civil appeal, you will always have to put the terms appellant and respondent, and you have to be very cautious while using these terms also in your oral arguments. And every page when you're referring to your own side as an appellant, mention it as appellant and mention it as respondent in the memo as well. Okay, invoking the correct jurisdiction, definitely you have to point out that under which law, under which provision of the law are we coming to the court. That also you have to mention. I'll just scroll down through a memo, a sample memo that I have downloaded. And after the end of this session, we have, and then I'll take your questions. So let me quickly go through this table of contents to the pointers that we have on our screen. Secondly, table of contents is also very necessary, because it is just like going to a library without knowing where are books kept. So if you do not have a table of contents, it looks shabby. Your marks will be deducted for sure. Of course, your memorial may not be rejected. Probably some moots like national universities do reject these memorials also. Even if you're very good in arguments, even if your application law is very correct, they will definitely reject you, because we have how you know or not. I know that how is it done, that when you apply for a moot court competition, we have a student committee which is headed by a faculty. They all check all these procedural aspects, and then only it crosses the first stage, and then it reaches the second stage. So in the first stage, if you do not have a table of contents, you are sending the judge or the other party to a library where you do not know which kind of books are kept in which shelves. So you have to have a table of contents, very very clear, pointing out the exact page numbers. If you have a table of contents but you have a wrong page number, even if for one chapter, that is also going to deduct your marks. Okay, then index of authorities is also very significant, that what all see, as I told you yesterday, that man is a social being. So as humans, we cannot survive in solitude. Okay, and that is why solitary confinement is also considered as one of the inhumane kind of imprisonment that India and other countries follow. But it is not given to somebody for life also, because we are humans, we need people to interact. Same is the case with law, which is a social science. Law cannot just take its course. It has to be given or substantiated with certain kind of arguments and other laws and precedents. So if I'm saying that somebody has committed a murder, I need to prove it. Proving it how? Proving it with the help of decided cases, which are called as precedents, proving it with the help of available provisions of law, proving it with the help of opinion and writings of distinguished people and authors and jurists. Okay, so index of authorities is nothing but a list of different kind of categories of authorities that you use. First category will include your case law, that I have referred to these case laws to substantiate my argument. Both these, see, these are contents common for both the memos of the respondent, if it's a respondent, and appellant if it's an appeal, and in a criminal and civil case also plaintiff, defendant, and accused and prosecution. These are all contents which are very necessary for each side of the memo. So index of authorities will have a list of cases that you have used. It will have a list of provisions of law that you have applied, and it will also have a list in the same heading, which is a list of writings, articles, sites. Nowadays we have sites and books of jurists and authors. So that should be very, very having a big sanction, because not every book can be counted as authority before a court. Supreme Court does not refer to every author. Even if I write a book tomorrow, and somebody, client of mine or probably a junior of mine, would say that I have quoted a book, I have quoted something from a book written by this novice academician whose name is Neha Purohit. So if it is not a renowned one which has proved it metal, it's not of any use. Okay, so try and inculcate books also which are very, very good, which are very renowned, and which have been proved. The next point of content is the statement of jurisdiction, which is the most significant of all of them. Why statement of jurisdiction is important? I will first tell you what is jurisdiction, and then only you can understand that why is it important. Jurisdiction is the power of a court to take cognizance of a particular case. Okay. Now, giving you an example of understanding what is jurisdiction is that a murder is committed in, let's say, Jaipur. Okay. And in a particular area of Jaipur, let's say Bunny Park. Bunny Park is an area. And the complainant goes to another area of Jaipur, which is, let's say, Amer Fort. Okay. Can the complainant go and file a complaint, or the informant file an FIR in a murder committed which is under the jurisdiction of Bunny Park Court and Police Station to the Amer Court and Police Station? Can it be filed? Can it be filed? Are? Just say yes or no.
Yes, ma'am.
No, ma'am.
Okay, yes, Abhishek.
Yes, ma'am, it can be filed
Okay,
in police station
Gungun.
as a zero
Gungun.
FIR.
Okay, fine. That's an exception case. Don't go to exception. I'm talking of general law. Okay, exceptions come after the general law has no place. Yashashwini says yes. Okay, and I saw one more, Gungun. I think Gungun Sharma had said no. Okay, see, whoever said no is the correct answer. Manvendra Singh has said yes. Okay, whoever said no is a correct answer when you apply a general law. Why? Because every police station and every court has its own jurisdiction. There can be three kind of jurisdictions, which are territorial, pecuniary, and subject matter. Every court has to have all the three. If any one of them is missing, the court is not able to take cognizance of a specific matter. So, jurisdiction statement, quoting in a memorial is very, very important for the fact that you need to have a sanction from the law, that this law gives me the power to come to you and I seek relief from your court because you have jurisdiction in this matter. So when you talk about, I'm not going into the detail of zero FIR and all that. That's a different thing that is not applicable in every case. Although it can be made applicable to some cases, but the problem is that if you give zero FIR, then in anybody in India can file a complaint or FIR in any court, and the court will have to proceed with its course. This is not possible. Not every court can take course. If I am sitting in a city in Bihar and I want to implicate somebody who is a resident of Maharashtra, I cannot directly go to the Supreme Court, and that is the place where jurisdiction comes into picture. So statement of jurisdiction will show you exactly that why, which section of law, which provision of law gives you the right to come to this court. If this statement of jurisdiction is correct, then you get full marks on it. You are going on the right path. If this statement of jurisdiction is incorrect, then your marks may be deducted, maybe your memorial may be rejected as well, or probably you may be grilled very, very um, grossly in your oral rounds. Okay, so do make it a habit that you find out the correct jurisdiction. Like going in a civil matter to a sessions court, putting the name of sessions court will is a wrong jurisdiction. Going in a criminal matter to a district court is a wrong jurisdiction. Okay, and then you have stages of courts also. So most of the times in memorials you have to approach the high court or the supreme court. Sometimes you have to approach the trial court as well. Okay. Yes, Ishita. Yes, Ishita.
Good afternoon, ma'am. Am I audible?
Hmm, you
Ma'am,
are.
what is the correct way of finding the jurisdiction? Ma'am, because many a times it is difficult to find the right jurisdiction.
Hmm,
Like
yeah.
for example, last time we had a
Hmm.
discussion on Hindu Marriage Act, and
Actually, you're not audible
there
properly.
was
So,
intent.
Ishita, I think I'll take your question at the
Am I
end of the
audible
session.
now?
No, your voice is breaking, and then I'll take questions at the end of the session. Do write your questions, and then I'll address it one by one. Okay.
Okay,
Let me just
okay, ma'am.
proceed with it, and I'll take your questions. We have a question answer session as well. Okay. So going to the statement of jurisdiction is very, very essential. Statement of jurisdiction is something that a bigger, broader way you have got to reach to a very, very narrow lane in a area. And if it is not correct, the court will automatically dismiss your petition, and then you will have no remedy. So it is better to proceed with the right jurisdiction of the court, and so that you have a space for going for argument. But sometimes the judges might say that you have come to the wrong court, and then you have no arguments. You will not be given a chance to advance your arguments, and rebuttal is, of course, not a question at all. Okay, so I hope you've got this. I'll be just scrolling down or sharing my screen with that memorial also, so you can understand. Those who are very novice to it, you can understand that what is this jurisdiction. Then you have statement of facts. Statement of facts is very, very necessary to be correctly pointed. What happens is statement of facts is the occurrence of incident that has led to your case. So for every case, you have a story in a in a civil or a criminal case. Every case you have a story. Statement of facts is nothing but that story that has led to you seeking a remedy from the court in the form of your pleadings, through the pleadings. So what has to be taken care of in the statement of facts is, first of all, read each and every line very, very clear. Okay. Secondly, do not arise at a conclusion as soon as you read the statement of fact. Do not arise at a conclusion. And thirdly, when you are making a memorial either for the plaintiff or for the respondent, sometimes you will see that the case is more bent towards the side of respondent, or sometimes you will see that there's no defense available to the respondent or the defendant or the accused or the defense at all. And sometimes you will see that there's more weightage given to the plaintiff or the appellant or the prosecution. Do not arise at a conclusion by just reading the facts, because there's always a way. And when I appeared for one of my interviews, I was asked a question that what is the difference between a lawyer, a good lawyer, and a very good lawyer. And I knew the difference between a lawyer and a good lawyer, but I did not know the difference between a very good lawyer. And what answer was I given to you? That they gave me a beforehand case and they told me that this case is clearly on the prosecution side. When a client comes to you, what will you do? So I gave some answers, and then the one who was judging me, they told me that in a case, whenever a client comes to you, you have to take only the client sides. You have to you have to speak to the client in such a manner that the client only reposes confidence in you. So look into the statement of facts, because the clients will tell you all the thing that they have not told to anybody, and there's a privileged communication between a client and an advocate, that you will not disclose anything which I am disclosing to you in the court, because as I said, this is your bread and butter. And if you are not the confidant of your client, then definitely no business. Okay. So statement of facts, read them correctly, do not arise at a conclusion, and do not think that we do not have a point to be proven as a respondent, or as a petitioner, or as an appellant. And the last thing is that whenever you are making a memo, statement of facts have to be correctly mentioned in the memo. Do not presume things on your own. You should not be presuming facts. That if a case is saying that he was lying dead and he was intoxicated, so we do not have to presume that intoxication was voluntary. If we are the plaintiff and if we are the defense, that we do not have to presume that yes, intoxication was given to you voluntary, because in that case, of course, you will your marks will be deducted in comparison to those you have mentioned the correct facts. And then there's one more thing, that you will be grilled accordingly. And then grilling during argument on the basis of your memorial, you have no way. You are just blocked. You are into this confinement where you cannot go back and you cannot move forward also. Okay, so do not add on to or subtract from the facts. This is what you have to do. Statement of issues. Issues is nothing which is the point of contention, the bone of contention between two parties. And issues are the point wherein the dispute has started, which has given you a cause of action to proceed towards the legal resolution. Okay. So now, how do you differentiate between the facts and the issue? Facts will be the story, all the story. Issues will arise from the point wherein you have a point of discord in the story. So, like I, I'll give you an example of that. A and B are a debtor and a creditor. So creditor gave some debt to B, and then the creditor started, after the time limit got over, the creditor started asking that when will you pay back me, when will you... The debtor kept on postponing it, procrastinating it. And the creditor then got frustrated one day, and then he said that this is the last time I'm telling you. If you do not give me, I will file a suit against you in the court. So what the debtor does is, he sells his property to someone else, and he says that I have no assets left, so that I can pay you back. This is the point of discord. This is the difference between the facts and the stage of issue, wherein you get a cause of action as a creditor, and you feel that now that I have no other remedy, because if I keep on pursuing this person, he will never give me back, and my limitation period is also getting exhausted. So this is the point wherein issues arise. An issue is the dispute pointers between two parties. So you have to mention what is the issue. This is my issue. This is issue one. This is issue two. You can have n number of issues, but I would suggest that issues should be kept as less as possible. It will depend upon the moot problem also, and the involvement of laws as well. Okay. So in that case, you have to write down that this is my first issue, this is my second issue, and this is my third issue. You can have more than one, you can have one also. If you are making one, always it is a problem that the court or the one who is judging you, they will always try and find out that were there not any other issues, are you not seeking anything, or do you not want to seek this redressal from this court. So they may ask you things like this. So it is better to stick to the issues 2 and 3, by 1, 2 and 3, and not more than that. I have not made a memorial ever, either for my students, which was not a good practice, as I told you yesterday, that although these students knew nothing and the date was approaching, so I was the one who made the memorial. but never ever go beyond four issues at the maximum. Try and minimize it, or try and deal with two issues together in one, under one heading. Okay. Then summary of arguments is whatever you are pleading before the court, it is that heading only. So pleading and summary of arguments, as you can see on your screen, you can take under one head. I have just pointed out for the contents because in memorials you have to put it separately. Sorry. uh, I'm not that in good state of my health today, so please bear with these disturbances of the hoarseness of my voice. um, so summary of arguments is nothing but your pleadings, which we will take up right now together with this. Pleadings summarized is the summary of arguments. Why is it done? It is not done in an original petition in the court. See, there are a lot of things which are missing from a real court petition, in comparison to your moot court memorial. So summary of arguments is something which is not a part of a real courtroom brief of a lawyer, but it is given in a moot memorial. Why? Because the main objective of it is that sometimes if you are giving promptly to somebody who's appointed as a judge, or probably if you are giving it a memo to the other party, if the other party is not, although you have to read it necessarily, they can go through the arguments and then see what are the laws that they have substantiated their argument through, and what are the cases that they have involved in these arguments. So your pleadings is the summary of arguments is the summarized or the concise forms of your pleadings. Pleading is nothing but whatever each party presents before the court in the form of their side memo, that is pleading. Okay. And you then keep on arguing upon that. I do not agree with this issue. They have refused this issue. Okay. So these are generally the pleadings concised under the heading of summary of arguments. And then is the next one. Yes, your pleadings have to be very, very elaborate. It should deal with each of the issues that you have mentioned under the head of statement of issues, and each issue should be dealt with separately. You cannot mix. If you have numbered those issues separately, each of them should be dealt with separately. And there's one more thing, that whenever you are making anything, writing anything in your pleadings, you have to be very, very explicit. If you are thinking that this the court will presume on its own, this is not done. You have to assertively deny or assertively accept something in your pleadings. Okay. If it is not there, then the court makes a presumption against you. So if I'm saying that I did not give consent to give credit to somebody else, I have to explicitly put this. If I'm saying that I did not authorize this person to sell my property, I have to expressly put this. Okay. And in a respondent or a defense memorial, also you have to expressly deny the issues or whatever is quoted in the pleading of the appellant and the plaintiff. Okay. So I hope then we can go on to the next one. Is it clear till now? Am I like, are you getting this? Am I able to communicate? Okay, thank you so much. Yeah, as you can see on my screen, thumbs are popping up. Yeah, thanks, thanks. Okay, so the last thing is your prayer. Prayer is exactly the relief that you get from, that you seek, you expect the court to give you. See, first of all, prayer is something which is exactly the prayer that you make to your own God. So, what I'll tell you a very personal experience as a very young kid. And in my growing years, I have this habit of praying to everyday praying, which I follow these days today also. So my parents have taught me to pray every day and thank God. And so as a kid, I did not know that what you have to. This is my personal experience. Your stories may be different. So my parents have taught me that whenever you are praying before God, if you want something, you have to explicitly tell Him that I want this. So, like when I wanted my selection in NLU, I prayed explicitly for it, and of course, I did my efforts also. So my mom used to tell me that unless and until you put it in a very concrete form, even God does not listen to, which I don't believe thoroughly. Okay. So prayer is also something that you put before this God of justice or the court, uh, and it will only give you that relief that you have sought. You will always be very humble. You cannot use a language in the prayer that is ordering the court, or that is telling the court that you give me this. Okay, you cannot use this language. Sometimes in your review stage of the memorial, as I told you earlier, that this is also one ground wherein the memorial can be dismissed in limine, that is without going into anything. Sometimes they see your facts, sometimes they see your contents, and then they go to a prayer, and then they see that this is not a language that is expected from a person who will move here, because reputed institution always believe in inducting or probably allowing students who have a very good acumen in this clinical education. So they will not let their reputation go down, and then this is why these sometimes you feel that this is very hard nut to crack, that this moot court, I am not somebody who would get through it. You can get through it, but then you have to keep in mind these things. Okay. And like a doctor also will not give you medicine unless you go and tell the doctor what is your problem. This is the exact thing with the prayer in a memo. So be very careful, ask for relief, and you can then put a line that any other relief which the honorable court deems fit. Yes, Vedant, I'll take your questions. This is going to just wind up. I'll take your questions. Do write your questions, and then I'll address them. Okay? Is it fine?
Yes.
Okay. Then going on to the next one. I hope these are the main contents of a memo. Do keep these things in mind. Now that we have come to almost end of this session, I would like to tell you certain things which are very, very important apart from these contents of a memo. And I'll show you a memo also which you can go through, and then I'll take your questions. Okay. So just be a little patient for the next one. Uh, this is your second one. Sorry. Yes, there are certain things that I would not want anybody to forget while drafting a moot memo. Is this first you read this, and then I'll take the screen to the Google Meet. So I hope all of you have read it. Just I'll just hide this.
And the slide has not been shown yet.
I think now it will be. Is it?
Yes, ma'am.
Is it? Okay, so you can read that there are 5 pointers that I've made, that either you can call it as things to remember or things never to forget. I rather put it in a negative manner, because there's one thing that I believe personally also. Sometimes when you tell people things in a positive manner, they're not able to receive it very nicely. So, not that I'm a pessimist person, uh, but sometimes when you tell them that don't do it, they will remember it. Of course, they will do it, but they will definitely remember that this person told me not to do this. So don't forget. That is why I've used this terminology, that don't forget. And what you don't have to forget is, first of all, while writing anything in your memo, you have to have footnotes while quoting anything. Now, what are footnotes? Footnotes are nothing but those very brief notes that appear under the footer of a page. You might have seen it. This is appearing in books also. Why do we put footnotes? Because these all matters that you take from any authority, from any case law, they are all copyrightable matters. And even if you take it from a site also, they are all subject to copyright. And if you do not acknowledge somebody's work, that is basically a copyright infringement. I would say that somebody's artistic work being stolen. So footnote is very essential. Get into the habit of it. Students usually don't do it. They think it's a very hectic thing. It's a hassle to put footnotes, but these things do count a lot. You can have jurist writings also in your memorial, but you have to quote them exactly from where are you taking them. This will help you fetch more marks. Then secondly, right application of law is very, very important. As I said, that jurisdiction statement is important. That was a broader lane will take you to a narrower lane, to the exact address, but right application of law is the exact address to your solution. So if you are applying, let's say, if a case is based on dowry death, and you are applying cruelty provisions in IPC, then you are wrong. Okay. So there are different provisions for each and every problem. You have to inculcate everything. If it is a memorial, which it is, if it is a moot problem which has 5 to 10 different types of laws, you have to manage that. There's no solution to it, that we cannot just be on the back foot looking at that. Oh my god, this involves almost 10 kind of laws, and I have to learn that. As I told you, that this will make you an advanced learner also. So correctly apply law, not just the statute should be correct, but the provision, the section and the subsection that you're taking is very, very correct. Again, I will point out that specificity is an attribute of law. You cannot go here and there, everything has a different meaning. And in that case, if you're not correct, you are doing a disaster, like I did in my uh, transfer property memorial. Okay. And next is that while you are arguing in your oral, because this is not just about drafting a moot memo. Drafting a moot memo may give you the prize for a best researcher, but there are cumulative felicitation attached to it, which is being the most the best speaker, or being the best team. So whenever you are arguing something, don't be aggressive. That is your choice to be done. I have seen people, I have judged debates and moot courts both. When I saw a lot of students, when they get into arguments, what they do is there is just a second, if I can pause here for some few seconds. Yes, I'm so sorry for this little distraction. Uh, mm. So we are back again to the argument or aggression. So the way your arguments are put are very important in front of a bench. Even in the court, even if you appear in the court, also your attitude matters a lot, because in real time court, what you have to see is very different from a memorial. Sometimes when you are, I think most of you who have mooted, I'm sure you might have felt that this bench was very cordial with us, and sometimes you might feel that this bench was very, very harsh on the mooters. Okay, have you experienced this kind of things while mooting? That some judges will be very, very soft on it. They will be very cordial. They will be very sensitive, and some will be very, very grueling, and they will be very harsh with the language. Have you?
Yes,
Yes,
ma'am.
Lydia. Yes. Oh, okay. So, so that makes an impression on us also, no? Isn't it? So if I'm very, very cordial with my motors, they will always remember this as, yes, we went to this moot court, and then even if we were wrong, even if we were not correct on the point of argument, they did not still grill us. Okay. So that makes an impression in the mind of in the mind of mooters also. Similarly, vice versa is also a thing, that this will leave an impression on the judges also. So when you are arguing, be soft, put your point assertively, but don't raise your voice even if they are grilling you. Even if you don't know the answer, you can just say, okay, I plead ignorance on this fact. Don't just keep on arguing and waste the time of the court, because that will deduct your marks. Even if your memo is strong, your argument is not your argument is strong, but your voice and your attitude is not correct, you will lose on to that round at that very moment of time. And when you enter the rebuttal also, even if your point is strong, as I said already, do not be in a haste, do not be very dominating on the other party, because it will also leave a negative impression upon the one who is judging it. Okay, so what we feel for others, others also feel the same for us. And specifically, it's not something that I would say that I have experiences all the times, but maximum times what I have seen is, while judging competitions, I have seen that majorly uh, the female mooters are very aggressive towards, if the parties in front of them are female. I don't know what is this chemistry, but pointing it out, not that I am not something who favors uh, feminism. I am definitely, being a female also, but then most of the time it is seen. It's my personal experience, you may not have seen that, you may not even agree with me. And the right application of law, explicit relief, as I said, that in your prayer you have to mention it very clearly, very expressly, and expressly deny also. If you are a respondent, you can say that don't give it to them. Okay, you can respect this. And relief under which law you are seeking, that also you have to put very clearly. And there's this one box, are you confused about why did I write don't be fair at all times? Who all got this answer? Who all got this box that points out don't be fair at all times? How many of you think that this is something which is weird? If Shita has raised Yash, this is weird. Is it weird or is it right?
It is right.
It is right. Okay. And anyone else thinks that it was weird? Okay. Yes, it is right from the point of view, when you are making a memorial, you are not judging something. See, you are going to be an advocate in that role while you're making a memorial. So looking at a moot problem, and as I said earlier, that weightage is more on the side of the plaintiff, or on the side of the defendant. Sometimes you read a memorial and then you believe that, oh my god, this is a clear rape case, this is a clear POXO case, and this is a clear case of fraud, and how am I going to take a defense from the defense side? So you don't have to be very fair at all times. The skill which a very good lawyer shall have will also be reflected in a very good mooter. So what you have to do is to extract what is for your benefit and leave the other. Even if you do think, even if it is a reality, sometimes we get moot problems which are based on real life cases. Okay, and they have already been decided by the courts. Is it? Okay, some most of the times we get moot problems which are based on real time cases, and they've already been decided by Indian cases, Indian courts, or any other court. What happens is we tend to have a mindset of sinking into the fact that yes, because the court decided it, we will also believe in the same thing. I, as personally as an academician, personally as when I was a researcher, when I was a litigator, when I am doing something else, I always have a different opinion if I do not agree with the court. So do not argue, but you can disagree with the court. So don't be fair at all times. Extract the best facts out of all the options, and even if you have one issue, prepare it so well that it can counter four issues of the plaintiff, if it is weightage on the plaintiff side and if it's weightage on the defendant side. Okay, I hope you're getting this point. Don't be fair at all times, because you ultimately what you want is your client's um, satisfaction. Okay, so when your client is not satisfied, then in that case, your being fair is of no use. Okay, so don't be fair at all times. Extract the best and apply the correct law. I hope you've got this. Have you got this?
Yes, ma'am.
Can I have some more thumbs up? Not from the ones who have already done it. Please
Yes,
share
ma'am.
clearly. Is it? This is, I hope. So then, this is my last slide, glorifying it, beautifying it a little bit. Thank you, and I'll just now go through this moot memo, and you can just see it once. and then we'll go back to the question and answer session. I had a great time because this was a very patient and a very involving. As I feel this, I am not sure whether it was involving for you or not, but I felt this that you guys were very very patient, and you were listening to it, every minute details that I had inculcated and tried to accommodate in this session of 2 days. I'll just take you to this memo when stopping the presentation for just 1 or 2 minutes. Just so I'll just share my screen, putting off the camera so that you can have a better focus on the memorial. Okay. This is the memorial, I think. You can just scrolling it down quickly. Am I able to share this? Like this is appearing on your screen, no?
Yes, ma'am.
Okay, see, this is the cover page. This is how you have to put. They will give a format to you, not that this is a standard format, but this is what I could extract as a standard format for everything. Especially petition 136. Then you have name of the parties, which is correctly pointed out, because when you are approaching a Supreme Court or a High Court, then you have to mention it as appellants and respondents, which is correctly mentioned here. Then Article 36 is for which, and memorial on behalf of the respondent. There are two colors of memorial of respondent and the appellant, which is this one, blue and red. Okay, blue is for the blue color is for which this one.
Petitioner.
Yes, blue color is for the petitioner or the one who is approaching the court first, and the red one is for the one who is
Respondent.
countering or taking the defense. Yes, these are the table of contents. Everything is mentioned here. They've basically extended this table of contents by putting on the argument advance. As you can see here, they put pointers also and the subheadings of these arguments advance as well. And secondly, national insurance. This is the second uh, argument. And then going with the prayer. This is mentioned all here. Abbreviations and all, I don't need to tell you. These are the authorities, index of authorities. Cases comes first, then you include laws, and then you include the books. This is a statement of jurisdiction. This is how you have to put. And then statement of facts, they point they you have, it is better to always put it in points or numbers. Okay.
Ma'am,
And then
can we see
yes,
the statement of jurisdiction, please, for a while, so can we
yes,
can
yes,
read it?
you can find it on the internet. There's no issue. There's a whole number of this one available. Okay, memorial. This is statement of jurisdiction. You can read it from the internet. I've just extracted it for the purpose of connecting it, because when you are hearing it right now and not seeing it right now, you will tend to forget a lot of things. Okay, so let me quickly scroll down. Okay, I'm so sorry for this, but I need to look into the time as well. These are the issues raised. See, they have put for memorial for the respondent on every page also, so it is clear. So when I pick a page which is not even that color, also the party who is reading it or the person who is reading will be able to identify that this is a memorial for the respondent. Okay, these are the issues. Three issues they've given. Summary of arguments have given 1, 2, 3. Only one page is sufficient for summary of arguments and the arguments advanced. Then they have mentioned footnoting. I found this as a very good memo. That is why I downloaded it. See, everything footnoted by them. Everything. Every case is also footnoted. Okay. Mentioning provisions and law. And then I take you quickly to the prayer of it. This is a prayer, very nicely drafted, very nicely and very elaborately put what do you seek in your prayer. Okay. So now I think we'll go back to our screen. So now I'll take your questions quickly. Yes, one question was from Ishita. Ishita first, because I interrupted her. Yes, yes, I'll take your questions. Just give me.
Am I audible, ma'am?
Yes, you are. Yes, you are.
Ma'am, my question is basically like, how should we find the statement of jurisdiction?
Hmm. You
Like,
can find it out.
it is very difficult. Yes, ma'am.
See, you can find it out from the moot problem itself. When the problem at the end tells you that this is the court, you have to file an appeal before this court. Uh, in that case, you will have to identify which is that court. Like if they are saying that you have to argue on behalf of the respondent through a writ petition. Now, writ petition from a court, which is a trial court, will always go to your high court only. Okay, it cannot directly go to Supreme Court. So you have to identify that from the problem which is given here. And
Ma'am,
sometimes,
I participate. Yes,
wait,
sorry.
sometimes when it is a court which is a sessions court, huh, uh, or it is a court of a magistrate or a civil judge, in that case what you have to do is you have to identify where does the appeal lie to. Okay, so the kind of a case which is given to you, that will always help you to identify which is the court of which what is the jurisdiction of that court that you're seeking. Yes, Ishita. Yes, you participated in one of
Yes,
them,
ma'am.
and then
Guys, you can write your question in the
Ma'am, it
chat
was the
box
case.
also.
yes, Ishita. Huh?
Ma'am, it was related to HMA, and international law was also applied there because the husband was from USA. So,
Hmm.
ma'am, it was quite difficult for us to find the statement of jurisdiction. The
Hmm.
case was filed in Punjab and Haryana High Court only. So, ma'am, in these cases, how can we find the statement of
See, I am
jurisdiction?
telling you, this is the key to find out the jurisdiction. It is mentioned in the problem. It is not difficult. It is difficult to find out because when you have not read the laws which are involved in that moot problem, it is difficult. But the hint to it is always the last line. It will always mention you have to argue on behalf of the appellant. You have to file a writ on behalf of this. Okay, so that will always give you a clue where will you be able to find it. Secondly, when you said that HMA and international law, unless and until I read the problem, I will not be able to tell you that did you approach the right court or not. But in case of international law has no significance uh, on the matters which are of national law, because this was HMA is a personal law, and in that case international law does not, or courts cases of international courts are not res judicata for courts in India. This is clearly mentioned in civil law. So you have to do a little research, which is a concrete research. Find out more and more, read more and more, and you'll come to know where do you file it, unless until you know procedural law well, because jurisdiction finding is a part of procedural law. Procedural law has to be read very, very cautiously, and then
Okay,
only
ma'am.
you can find
And
out.
yes, ma'am. One more thing, like in civil cases, you said it was prosecution and defense.
Yes, no, civil cases, I
Yes.
said it is for criminal cases, not for
Oh,
civil.
sorry. One second. Yes, it in civil it was plaintiff and defendant, ma'am. And in civil cases we call it as appellant and respondent as well, right?
You call it as appellant and respondent only in case of a writ being filed. Appellant is the word which has come from appeal. So one who appeals becomes an appellant. So if appeal is a civil appeal, then also it is appellant and respondent, and if it is a criminal appeal, then also it is appellant and respondent. If you are made to file before a particular trial court, because appellate courts are not trial courts always. Okay, so if you are made to write
Okay.
before an appellate court, before a trial court, then your terminology changes. For a civil or criminal appeal, it will always be appellant and respondent. Okay.
Okay, okay. Thank you, ma'am.
And I think a lot of students are then waiting. Yes, I'll take Vedant and I'll come to Ipsita then. Yes, Vedant.
Vedant, you can write your questions in the chat box, and I will read
Ma'am,
Ma'am
could you
Vedant's
please,
questions.
Uh,
uh,
huh. Yes, who has a question?
ma'am, can I please say it?
What is that question? What is your question,
Ma'am,
Vedant?
yes, ma'am. Could you please point out some common mistakes that student like generally make while formatting a like memorial?
Yes, common mistake is first of all your cover page title names are very they are not correct mentioned, which I very emphatically had put. And second is that a statement of jurisdiction is most of the time wrong. Those memorials which achieve the status of being the best memorial, they point out mostly the right application of laws, and the statement of jurisdiction is also right. And then the language in which you draft a moot memorial is also very very shabby. It's a very lethargic language. Most of the when I who as a reviewer, if I would select somebody's memorial, I will be very impressed if the one who has made it have applied jurisdiction correctly. The laws are in place and the language is very very emphatically, and then the prayer, these are the points which are very common generally I've seen. And secondly, I will also reject a memorial and the team if they are showing very very their attitude is very hasty, they're very aggressive, and they are wrong, and then they're exactly pointing out, yes, we have done this, we have done this, we've done this. And sometimes what happens is students tend to not know the law and they don't research on it, and when a law is repealed or a law has been amended, they are not aware of the amendments in the law. It is better to always keep ourselves updated with the latest trends in law, because in law, if you are not updated, that means you have gone back for 3 months. If you don't get yourself updated, I feel that you've gone back 5 years in time without knowing what is happening around us. So these are the things that I would reject a memorial on. Yes, anyone else? Somebody's written it
Ma'am,
on
and could you
chat
please
box.
also point out the difference between pleadings and prayer?
Pleading is something that you are arguing upon. Your arguments, basically whatever you advance as that substantiating and elaborately mentioning, are your pleadings. Pleadings will start from the fact that these are the facts, the respondent will say that these are my facts, and the appellant will say that these are my facts, and on those facts you will argue. So pleadings are very very elaborate. Whatever you want to tell the court orally, they are all put in a document form with the evidences that you are ready to produce before the court. Prayer is just the relief that you are getting. You never write in your pleadings that this is a relief I seek. You always write, this is my problem. And why am I denying this, or why am I asserting this? You will always write in your pleadings. You will always write in your pleadings that this is something that I will be proving if you are asking me to prove it. Okay. Pleading are substantiated by laws. Pleadings are substantiated by case laws, and pleadings are also substantiated by writings of distinguished jurists as well. But prayer does not have anything like that. Pleading comes in a moot memorial. Pleading comes before the prayer, and prayer is the last part of your moot memorial, wherein you are only very briefly pointing out that what do you want from the court. So first you tell your problem, like we approach our parents, and then if you and your siblings are fighting and you tell your mom that you don't tell them that I want this, you tell them that I want this because this has happened. So first you tell the reason, first you substantiate, and then you seek what you want. I hope I'm clear. Mm, yes, yes, you can definitely skip facts if you think that they're not important. You don't need to mention each and every fact. You can shorten them. You can put them in a concise form. This can save your time, and this can also save your page numbers. And this can also save. Sometimes what happens is the opposite party. What I've seen, like Vedant had asked that what is the problem with moot memorials. I have seen not just moot memorials, but the parties appearing have also a problem that they don't read the memorials of the other parties. Okay. And when you don't read the memorials, you are having an advantage. So you can skip certain facts which are of not benefit to them, but the benefit advantage of other party. And if the other party has not read your memorial at all, they will forget to point it out in your argument. So you can skip, but don't skip your advantages, this one part of the facts. Second question is, what is the second question? uh, Let me
What
just
is
go
the
back to this
correct
question.
method? What is the
Correct
correct
method
method
of
of
application, this will all depend upon the moot problem. The more you read, the more answers you will get, that what is the application of law to it. This will all depend upon the kind of moot problem that you have got. There's no straight jacket answer to it, that how can I apply the law exactly to a particular moot problem. Okay, read the moot problem thoroughly, go through every line, and go through the judgments of the trial court that has been given in the problem, and then you will seek do a thorough research on it, and then you will be able to find out what are the laws involved in it. Yes,
and ma'am,
next.
there,
Wait,
ma'am,
I'll read that question. Difference between moot memo and real petition. Whole lot of difference in a moot memo and real petition. It is not exactly how it is put. In real petition, we have annexures. Moot memorial, we have compendiums. And moot memorial is very, very precise. In a real petition, a lot of practical things are involved. Real petition involves procedural aspects like giving it, taking it from notary, and then following a lot of procedural laws things. So it's a whole lot of difference between them. But why is it similar to this petition? Because it will help you learn the art of uh, uh, giving your client a satisfaction even if you do not have a case. So you will learn the art of how do you extract the best out of certain situation to seek a solution to your problem. Okay.
yes, ma'am. One
Hmm.
more question.
Wait, Ipshita, let me just read this. Yes, what is your question?
Ma'am, that often there is one issue of maintainability. So, what exactly we put or we write in the argument of maintainability, that whether this petition or this case is maintainable before the
I'll
applied
tell you.
court?
This is very important and a very nice, very, very significant question that nobody is asked. Because I think you have mooted quite a number of times and you will be knowing it. Maintainability is a very important task. See, when you approach a court also in real time, what happens is the court will see your petition on two grounds. First, on the issue of fact, and then the issue of, first on the issue of law and the issue of fact. Facts and everything the court deals with later on. What the court first checks is whether this petition is maintainable or not. Maintainability is nothing but there is a time limit for each and every case to be filed. Civil cases, there's always a time limit. Criminal cases, if the imprisonment is more than 3 years, there's no time. But less than 3 years, there's always a time to approach the court. So if you approach a court after that particular time limit, your petition is not maintainable, which is given under the Indian Limitation Act. If you approach a wrong court also, then also your petition is not maintainable. And if you are approaching, please, I expect that you mute your mic when I'm addressing something. Thanks. So maintainability is nothing whether this can be entertained by the court or not. And entertainment by the court or cognizance by the court are dependent upon limitation, are dependent upon whether you have a cause of action, whether there is a real petition or not, are dependable upon the power of the court to take cognizance. Because if you go to a court which can only give imprisonment for 1 year, and you are seeking imprisonment for a person who has committed a murder, then that is also not maintainable before that court. So maintainability can be checked based on the court's power to take cognizance of the case. So before you approach this court, any court, you have to see whether your petition is maintainable or not. Court also does not take cognizance of trivial matters, that somebody stole a samosa from some shop. So if you go to the court and then charge him of theft and seek 3 years imprisonment for that, the court will say this is not maintainable. We don't take cognizance of trivial matters. So existence of or taking of cognizance by a court is a maintainability of a petition, and the court has a parameter to be decided whether this should be entertained or not. I hope you got this. Yes.
Yes, ma'am. Thanks a lot.
Okay. Next, there's one more thing. Who had asked me questions? Yes, facts are against our client, and how can we extract the things of our interest? This is again depending upon your own skill and art, and what kind of facts are given to you. What you have to do is that don't be judgmental. If you're saying facts are against us, yes, facts may be against us, but facts may be favoring us. This is the skill that we have to develop. That how do we do this? How do we take favor in of our client in a case wherein you do not have anything in your favor at all? This is your art which will make you a very good advocate. I'll tell you one thing that just avoid being judgmental, avoid being so fair that, oh my god, I do not have anything in my favor. Even if you do not have anything in your favor, what you can do is just counter the argument, say no for everything that has been mentioned in the petitioners or the respondents memorial against you. You say no, this is not possible. You if you do not have any law in your favor, you argue on facts. But law should be used first. Arguing on facts is a later thing. But if there is law available, you use that law. Facts will not help you. Okay. And you can twist the facts, but in a moot memo, you cannot, as I said, that you cannot add or subtract the facts, because then it will be a problem. The court will ask you that where did you find this? In the facts, there's nowhere mentioned. You can do twisting of facts in in a real petition. Okay. So read it. Don't be fair at all. That is why I said don't be fair at all. So then it is possible that both the side feels the case is maintainable. Yes. And about maintainability, I'll tell you one more thing, that as a petitioner, you will never put this as a one who is initiating the proceedings in a court, you will never ever put in your memorial that this petition is not maintainable. Okay, you will always say that it is maintainable, and as a defense lawyer or defense mooter, you will always say that this is not maintainable, because the defense wants what? They will always want that the petition be dismissed. We don't want anything to be going against us. So if the court takes up the petition, we might lose. But as a defense, as the counterparty, you will always have to ask the court or tell the court that this is not maintainable. We just reject this contention of the appellant or the initiator of the case. So in a maintainability case, petitioner, prosecution, and appellant will always say maintainable. And the first issue that the defense or the accused or the respondent will take is that petition is not maintainable at all. This is a wastage of time of the court. Okay. Yes, Harshita's question I've taken, Raghav's question I've taken, and then this is also taken. So I guess there are no more questions now, and I can see the number of people also exiting the meeting. So
If you allow, let me ask one more question.
yes, Ipshita, if we have time.
Ma'am,
I have only 2-3 minutes now. Yes.
I wanted to ask about rebuttals. That what exactly we can counter, what areas we can
Re-
counter that process.
Rebuttal, you have to go through the petition, the other party's memorial very very clearly, very very thoroughly. You have to go through, and secondly, whatever they are saying in their oral arguments, do make a note of it. If it is not matching with something that you have put in your memorial or in your oral arguments, you can counter them in that point exactly. Reading their memorial will help you in rebuttal a lot, and prior, much prior to your day of arguments, is a tip that you have to read it very carefully. You have to match it with your memorial. Once your memorial is submitted, you don't have anything in hand, but still try and counter it by some kind of arguments which are strong on your part. Okay, strong on law on your part. Okay.
Okay, ma'am. Thank you so much,
Huh.
ma'am.
So then, I guess we've come to the end of this very indulging session for me. Especially, I never expected that people will be engaging themselves such in a gross manner. And when I came to know that some students are in a pre-law school stage, that is what was more striking for me. So you have such an interest for this. I never believed that students can come to workshops also during their summer breaks. But it was really nice. I have learned a lot through this exposure, and I thank all of you for being patient, all of you. I wish, I think this is a success for me, for not for you, or whether it is a success for you or not, that I can't be sure. That only if your feedback will tell me. But thank you so much for being patient. Thank you so much for getting involved in this, and I hope you've taken away something very, very positive and insight into this mooting thing. And one tip as a teacher and an experience as a student, I would don't believe in hype created by students. Peer pressure also plays a lot of part in creating pressure on the mind of other students who do not take an active role. So it is important, it is good that you do, but don't put yourself in a position, or don't make yourself believe that you are lesser than anybody else. Be always motivated, and just uh, proceed. All the best and best wishes for your future. Thank you all.
Thank you so much, ma'am.
Thank you so much, ma'am.
Thank you, Paras. Yes, I can see the organizers here.
Yes, ma'am.
Yes.
Ma'am, I was waiting for the audience to ask one question that on behalf of them, I am asking, what is the importance of compendium, ma'am? As I have seen people carrying a bundle of books, papers, print out thousand pages of printouts. What does they really play a role in the moot court? They are just bluffing.
See, compendium is important. Sometimes, see, some universities require compendium, some of them don't, because it is important for the fact that it is easier for you to quote things. Okay, compendium is nothing. What if me and Shubham are talking about this compendium? For those who don't know, compendium is nothing but whatever authorities you have cited, you take them with you in hard copy. Okay, so it is easier for you to cite things if you take this compendium. It is easier for you to refer also, because as and when the court says that yes, not every judge will know everything in your memorial, no. So it is easier for the judges also to refer to it, and it is easier for you to refresh it if you have forgotten something. So taking it, if you have, for personally for me, I do not believe in carrying these things as a companion, because it is a burden then, because most of the times you have to go outside and then move. So it is a burden for me. What I do is, I just what I've done is, I've always put it in my laptop, and wherever it was needed, I've given it a thorough reading. So I've made notes and I've put this. If it was required in any mooting, then only I've carried that hard copy. Otherwise, I've not carried it. So you can put it in your folders and then show it to the bench that this is where it is given already. Okay. This is the only significance for a compendium, for my opinion. Okay. Otherwise, it may be required by a lot of organizations. That's their discretion totally.
So, ma'am, I really want to thank you for joining with us.
Thank
And,
you.
ma'am, I have myself participated in a lot of workshop. And what different from other workshop in this was that on the first day you pave the way for what is necessary, and secondly you cover the entire topic. I have myself participated and I have learned that both the day only the structure of memorial making was being taught and nothing insight was given. And in this particular workshop you have provided with lot of information. Jurisdiction was the best part, that my myself has faced lot of problem in covering that. I really want to thank you, ma'am, on behalf of entire legal vidya team and on behalf of entire participant who have joined this workshop. And I believe that they will definitely gain something and the learning will be much more. Thank you so much, ma'am. Ma'am, you have to unmute yourself.
Sorry. Even I enjoyed it a lot, and it was a learning experience for me. I have participated in a workshop, but every workshop is different. Every person is different. Every experience is different. So I've learned a lot from this as well, and look forward for engaging more of such sessions in future as well.
Thank you so much, ma'am.
Thank you. You guys are doing a good job. All of you. Legal Vidya is doing a very good job, and I hope all the success and great achievements for all of you. Okay.
Thank you,
Thank
ma'am.
you, and have a great day.
Thank you, ma'am.